Hello, and welcome to SLW Institute's International IP webinar series. My name is Greg Stark, and I'm principal with Schwegman Lundberg Woessner. Today's webinar is entitled Claim Drafting Strategies for Multiple Dependent Claims. If you'd like to, a little bit of housekeeping, if you'd like to, one, we're recording this, as probably you noticed, as Zoom, I think, asks you or tells you. But if you'd like to submit a question, please feel free to use the Q&A feature on the webinar menu. We'll address those at the end, or potentially if they're particularly relevant, I may interrupt John and interject the question. This webinar series will be presented by Dr. John Collins. John is a UK and European patent and trademark attorney who heads the UK office of Schwegman Lundberg Woessner. John has considerable experience in proceedings before the European Patent Office, including oppositions and appeals. He also has litigation experience in both the UK and the US. Accordingly, John is very well equipped to teach us the finer points of claim drafting for EP practice. Thank you for joining us, and with that, I'll hand things over to John.
Thanks, Greg. Yeah, interesting topic. One which, strangely, over my many years, I've not given before. I was talking to my colleagues earlier. It's really interesting. It's something as European attorneys we take for granted, and I think for many of you US attorneys, this is always something that's a little bit mysterious and a bit complicated and confusing, I find, at times. So, as an outline of the talk today, I want to focus. There's a lot of discussion really about the EPO, or the mention about the EPO, because although the European Patent Office is not the only country that enables use of multiply dependent claims, it is a serious driver or cause for the need for multiply dependent claims, as I'll explain in more detail in a minute. And so I just want to take you through the legal principles. I'll talk about an approach to structuring the claims and explain some thought processes that you need to go through. Talk about a tip really for US filing, thoughts for when you file in the US. Then talk about what to consider when you then file in the EPO, the conversion and avoiding claims fees, and of course, a wrap up at the end. So let's talk about some legal principles to think about at the beginning here from the EPO. The Article 84 requires claims to be concise. So unlike, although over the last quite a few years now, US claims have been driven down by high claims fees, historically European claims have always been under pressure due to Article 84. Which requires conciseness, and therefore the examiners have the ability to object if you use multiple independent claims. The point about the law is there's certainly no express exclusion to the use of multiple dependent claims, multiply dependent, and historically the practices in patent legal systems in Europe have openly accepted them. Claims fees are expensive. So that's one thing to consider regarding using multiple dependent claims. If you are considering doing the calculations, it's purely based on the number of claims, not based on any calculation of dependencies as in the US. So simply count the numbering system of claims. One of the key drivers for why I'm focusing on the European law here for multiple dependent claims is the very strict basis requirements for amendments in the EPO. When you make an amendment to claims, the basis required for this is that the disclosure must be directly and unambiguously derivable. So the claim scope that you're trying to claim must be directly and unambiguously derivable from the application as filed. And beware, there's a wonderful term that the EPO have come up with, which is intermediate generalization, which means that you have taken a feature from the level of the scope of the embodiments and generalized it up to the scope of the claims without explicit or the direct unambiguous derivability required, which is why you need to ensure that the claims have this dependencies to enable claim combination where possible. And a final point on legal principles is that this sort of directly and unambiguously derivable concept of basis for claims actually flows right the way back to the priority claim. The US application typically is filed and used as a basis for priority, and then you come to the EPO, and it's important to be able to retain that priority claim. And the EPO will use the same standards to assess whether your amended claim, your claim that's on file as granted or as being examined, has the same standing, has the same basis. Does it have a right to priority? So it's important right from the start. So then looking at some types of claims, again, this is from a bit of a European angle. The European system only allows a single independent method claim and a single independent apparatus claim normally. There are exceptions. Very few EPO examiners will allow anything other, except for specific exceptions, such as transmitter-receiver type inventions, client-server, plug-socket, encoder-decoder. That sort of way the invention may be recitable as an encoder and a decoder, having common technical features. And computer readable medium claims, just cover this, it's quite important. These can cover both storage media and a transitory media, a signal, in one scope. And so really, wherever possible, use a broad term with two branches in your specification. Avoid stating that there's only one disclosure of a medium and that medium can never cover signals, because you lose that scope in Europe. If you simply say there's a computer readable medium, and it could be a storage media or a signal, and in the US, we're only claiming a storage media and disclaiming a signal, then when it comes to Europe, you have the basis required to cover signals, which can be very useful for downloadable software. So allowing claims, the allowable claims in Europe can significantly deviate from the practice in the US by the ability to cross over between categories. An example here, I've given 3 different examples, would be a method of using a system of any one of claims 1 to 5, for example. Typically, you try to avoid tying the method back to the system, but sometimes the examiner considers that the technical features of the system are essential for the method. And rather than trying to recite the technical features in the method in a rather complicated manner, you can simply use this form if you have to do it. It's preferred not to, but note, again, you have a multiple dependency going through from a method claim to a system claim. And similarly, and this is something these next to a claim forms I use all the time for conciseness. In TDA, I normally delete the full set of system claims wherever possible and use this form. A system comprising a processor and storage medium, and of course in this case it is a storage medium because it's a computer, has a memory. And a storage medium which when storing instructions which when executed by the processor cause the system to carry out the method. That does away with a whole set of claims. One dependent claim, very, very useful. It gives you a lot more headroom for method claims without, based in your staying within the 15 EPO claims, for example. And similarly for storage media or machine readable media, covering both storage media and signals. A machine readable media carrying. Now, note the word carrying, chosen carefully. It doesn't store, it carries. That covers both storage and transmission. The medium carries the code. And this is again dependent on the medium, on the method claims. Just as a little note, footnote here for those of you in software, it's useful as a means. Basically, the method claim doesn't need to recite a processor anywhere in the claim. It does need to refer to the use of technical means, but the EPO is very, very relaxed on this. The 101 sort of problem, there's no technicality. They look at what its function is and what it's doing, as long as you do recite, means and a computer implemented method is enough. And that's surprising for many US practitioners, that simply reciting this computer implemented method, so long as there is some element of technical processing going on, which will be evident from the steps. If it's very ambiguous and abstract, that may not be enough, but that is usually enough. Anyway, let's slide aside on the multiple dependent claim drafting, but it shows the different types that are available. So going on then so how do we go about drafting claims which have these multiple dependencies, which have some sort of logic to them? Now, as ever in drafting, you need to identify the claim features, which are your core claim features for claim 1. And you then need to identify the modifications, the preferred embodiments, the preferred features. You then need to map relationships and possible combinations between them and understand what can be used with what. And not simply rely on some later on being able to say, well, you could use that with that. If you haven't said it, the EPO will not let you put it in. So when you consider possible combinations, you may need to reorder the list of features that you have identified to try to get some logic and structure in there to ensure that you get a correct dependency relationship. And an interesting form in the used in the EPO, and in some countries allow this form, is a sort of a conditional dependency. An example here is a method of claim 5 when dependent on claim 3. And for some reason, you've gone from claim 3 to claim to claim 5. Claim 5 can't depend on claim 4 because they are not compatible. Now, in that case, generally, most times, there is a better way of structuring your claims. Sometimes it's just not possible because you've identified a particular structured relationship which does not permit that. So what I've tried to do now is to take through some examples, and hopefully they're not too complicated, but I needed to put enough in this to give it a bit of substance. And I've used simple geometric shapes to indicate features. In this example, we've got 5 embodiments disclosed, and embodiment 1 has features A, B, C, and D, and there are modifications to those features. So A prime is a modification of feature A, B prime, modification of feature B. And this is disclosed within embodiment 1. Similarly, in embodiment 2, we have 8 features A, B, C, D, and E, again, with slight modifications to those features as indicated by the primes. Embodiment 3 now has features A, B, C, and E, no D. So it's a different embodiment. Embodiment 4 has A, B, C, D, E, and F, but D and E are mentioned specifically as being optional in that combination. And then as a final wrap up, at the end of embodiment 5 is a particular feature which has 3 different modified versions, and that is for use with embodiments 1, 2, and 3, but not compatible with embodiment 4. So we've identified, if you like, a set of features that need to be claimed. How do we go about this? Well, we've identified the features. So claim 1 is a generalized description as far as possible, assuming that there is that is sufficient novelty and inventiveness. You've identified A, B, and C. And it's important that that is specified as claim 1. You've now got a whole string of optional features for dependent claims. Now, typically in the US, these would have sort of one line back to claim 1. So A prime, B prime, C prime would just depend on claim 1, as would D. And D prime, maybe it's dependent on D or claim 1, etc. But they're linear. So how do we enrich the generalization of the embodiments to provide the support? How do we use multiple dependencies? I came up with a map which, excuse the horrendous complexity, if I walk you through this, I sort of called it a mind map. It's the thought process that you need to go through when you do this. So if you look, it's almost like going around the clock here. If you start off with A, B, and C, as you go around, feature A prime rather, simply depends, follow the arrows on A. B can be dependent on A prime or claim 1. And feature C, C prime rather, can then be dependent, follow the arrows up. 3 dependencies, it could depend on A prime, B prime, or claim 1. Same, and then we should go around the clock. Next one, D, that's got 4 dependencies, reaching back to each of the previous claims. Now along comes D prime. Now D prime is different because it's a special case, and that hangs off the back of D. Looking then around the clock, moving on to E. This, again, no reason why it can't depend on everything else. Facing backwards, it's everything that's preceded it. E prime hangs off the back, moving on to F. Again, all the arrows shooting off to the left, the dependencies possible. F prime can hang off the back because it's a special case of F. Now we have an interesting case of G. G cannot depend on F. So all the arrows shoot back, but they do not hit F. And then G prime and G hang off the back. So that's the sort of mind process, the thought process that you go through. And this is the claim structure you end up with. And I've kept the picture in mind because it does help. And if you look through a method of claim 1, claim 2, notice in green, I've got some arrows there because I wanted to point out that these are single dependencies. So as you go through, the dependencies increase in number. Claim 2, method of claim 1, claim 3, a method of claim 1 or 2, claim 4, cumulative, any one of claims 1 to 3, 4, any one of claims 1 to 4, claim 5. Now this is a single dependency because D is a special case of, D prime, special case of D, and so on. So you get to 13 claims, and believe it or not, I didn't actually engineer this to be this clever, but it happened to fall to be this clever. You have 13 method claims. I'm assuming this is a method because that is my technical field, software. And then along comes the system claim, which is simply multiply dependent on the method claims and machine readable medium claim. And hey presto, I've stayed within 15 claims. And yet I've managed to cover that web of complicated combinations of possible features at the generalized level of the claim language. So the points to note, I think I've mentioned some of these already, that if the features A, B, and C, that's claim 1 in combination. Claim 2, it would only allow, or only needs to define A prime. It would cover A prime plus B plus C. If claim 3 were only dependent on claim 1, this would only cover the option of A plus B prime plus C. Whereas there are the other options which you can work out for yourself there. And if claim 4 were dependent on claim 1, it would only cover A plus B plus C prime. And of course, there are the other combinations which are possible and should be explicitly disclosed and covered by the claims. And you'll note I say the word disclose. Under European practice, the claims are considered part of the overall disclosure, and they support themselves. In the old days, sometimes they would say, well, you need to sort of write the language of the claims in the description so that they're supported, but that's not done anymore. The claims are part of the disclosure. With regard to features D, E, F, and G prime, all the primes, as I've mentioned above, before, these are single dependencies noted by the green arrows. Since they're just special cases of the individual prior claims, D, E, F, and G. G is somewhat different because it has 2 options, G prime and G double prime. Hence, G double prime must depend both on G and G prime. I give an example here that G prime states, G is states that pulse is used as signals, whereas G prime states that the pulse height is 1 volt, and G double prime states the pulse width is 1 millisecond. So of course, you want to cover the combination where the pulse height is 1 volt and the pulse width is 1 millisecond. So you need a combination of G prime, and G double prime all together. And of course, as I mentioned before, features F and G are not compatible at all, and therefore they should not be made dependent on each other. So it's, before moving on, so that's a sort of complicated way of showing it, but there is a logic going around the clock to show how you develop those features. And the important thing is to consider, and if necessary, move some of those features to avoid these arrows crossing in an uncontrolled manner. There is logic to the way in which this is done, and sometimes you just have to move features in your list so that they do naturally sit and work together. It does take time when you've written out all these possible features to work out which ones need to depend on what. So moving on then to tips, or a tip, just really to one tip. Assuming that you're filing in the USPTO, and you go, well, that's all very nice, John, thank you, but of course, the USPTO does not permit us to use dependencies and multiple dependencies in the way you're talking about here, particularly, of course, the unallowed multiple dependencies on multiple dependencies, and the fees just become horrendous. So how do we help and secure our position in the US? Once we file in the US, how do we secure our position going forward internationally, particularly for Europe? And the answer is to include disclosure, which maps to the language of the claims you need. And I don't believe that has any detrimental effect on US practice, but I'm happy to discuss that with anybody who believes there is. But if you simply include somewhere, and this is just one example, I'm using the word examples, include the wording of these multiple claim dependencies in a form that looks like claims, but call them examples. And here's the example I'm giving here. Under heading examples, the following numbered examples are embodiments, and you number them, and you just take the word replace. Example, the word claim, for example. And this will provide absolute explicit basis going forward. And at some point, you can always delete. If this is unnecessary in the US, it can be removed at some point later. So that provides you, the point is that this is done at priority date as soon as possible in the US, ideally, of course, right at the priority date. That provides your explicit basis for multiple claim dependencies at the US. And therefore you have secured your priority claim. Okay, what about going the other way? And when you have maybe, if you're lucky enough to receive, as we do sometimes, receive a US style specification set of claims before filing a PCT, or that's going to be filed at the EPO, or before filing a normal European application claiming priority. But typically, more typically, it's a PCT regional phase filing. And this would be an example here of a typical US claim structure. Single dependencies with a method claim, system claim, machine readable medium claim. I'm not sure I've breached the typical 20 claims. Some practitioners are quite firm about staying within 20 claims. But that is single dependency. So, first of all, that's more than 15 claims. So that's, if we're going to look at this, what can we do about this? We don't want to pay the European Patent Office. They have plenty of money. They don't need any more. How do we avoid the claims fees without losing claim scope? And the simple answer is we use the allowable forms of claims that the EPO are quite happy with, and we refer between the categories. So in this simple example, we have 7 method claims. We don't need to repeat those claims as system claims. We can simply make a dependent method claim, a dependent system claim rather. And similarly, for the machine readable medium claim, we can remove that. So we've immediately cut the claims from 20, which would have incurred 5 claims fees, to 9 claims without any loss of claim scope, and indeed retained a more concise, compact set of claims, which are easier to work with. Whenever you amend claim 1, you don't have to worry about, oh, I've got to make the amendment to claim to the system claim. You just do it once. It makes for a lot less hassle and avoids the claims fees. Now, if this is a PCT regional phase and you have been good and included numbered examples in the multiply dependent claim form in your description, when entering the regional phase in Europe, you can also take the opportunity to introduce the multiple dependencies back. Or not back, but introducing them, sorry. So you're from claim 1 is a single dependent, sorry, claim 2 is a singly dependent claim, naturally. But claim 3 could be dependent on claim 1 and claim 2, or claim 2. Claims 4 to 7 can be dependent, or maybe obviously not claim 6, that is dependent on claim 5. But so that leaves 3, 4, and 7 could be multiply dependent claims. If you have the basis, now's the time to add it in. You don't pay, it's there, it's available, you're amending the claims. You can do it immediately on entry or wait for the Rule 161 communication, for example. But this is an approach that can be used in Europe to reduce claims fees and focus the claims. So again, that's just using the same practical teaching of how to consider claim reduction. So this really, in summary, it's quite a short talk, and I'm hoping we'll engage some conversation here. Multiple claim dependencies, they're a useful tool for international patent drafters because it's not just about Europe. We're talking about other countries where you'll benefit from this relationship between claimed features. It's an essential consideration for a strong European patent. But in order to be able to make this work, you need an organized approach. You need to structure your mind, structure the features, and make sure you reach back to the correct dependencies. And remember, when you're doing this, that you can do this at filing in the US, and of course then when converting a US style specification for EP filing. So I hope it's quite a short conversation presentation, because I hope to have conversations regarding people's thoughts on multiple dependencies, because it is quite a simple topic, yet quite difficult.
Well, thank you, John. That was very informative and super useful. So we do have one question at least. Benjamin has presented a question in the Q&A section. He asks, when drafting an example section, is there any downside to having the multiple dependencies in the example section blindly depend from all preceding claims, regardless of whether the limitations are compatible?
That's an interesting question. I've seen this done quite a lot, actually. And as yet, I have never had an EPO examiner pick up on that. But there is a danger. The European Patent Office in particular dislike boilerplate language, where you simply state somewhere all embodiments can be used with any other embodiment. And there is a danger that the EPO examiners can get a little hot on this sometimes, saying simply you have used a boilerplate type dependency without any thought or without real clear, teaching is the word, the disclosure, and you have covered clear inoperable embodiments leaving the reader to have to experiment to work out which ones might work with each other. So whilst I've not seen it objected to by an examiner, believe me, I'm sure there's one out there waiting to try that, because if you can, the example would be, sorry, their possible objection would be, well, you've just set a puzzle for the skilled person. You've not taught to the skilled person that combination, the real combinations, because many are incompatible and the skilled person wouldn't know which ones are incompatible. So be very careful about that, because that's a possible objection either by the examiner, or if you end up in opposition, it's certainly one I would be playing with.
So I'll interject a bit of experience there. I have had one EP examiner highlight this as an issue and ask for us to amend the specification to correct. And it really happened in this case, I think, because there were some very clearly distinct embodiments that were not compatible, and the spec was drafted in the manner suggested by Benjamin, and it just made for there was some things that it was very obvious. We weren't claiming any of those things, but the examiner did pick up on it. It is, and I've prosecuted a lot of cases that have been done this way. So, I'm with John. I think it's something to be careful about.
I think
right.
Sorry, Greg. Yeah. So the point there is, yeah, it's fine if you can simply amend it. But the danger is that the examiner says by amending it now that you're actually, it's almost like in the field of chemistry, it's not my particular field, but you're making selections of now things you say that can be used in combination, and I'm not going to permit you to make that amendment. I can see a clever examiner bringing that one out. I suggest it would need to be shipped all the way, possibly even to the enlarged Board of Appeal to chew it over. But it's you're supposed to be teaching something, and if you just use boilerplate, you're not really teaching things. You're just spreading stuff out and hoping something sticks. So I would urge a little bit of caution. I mean, there are some odd mistakes are fine, but simply making every claim dependent on every other is, I think, bad practice and should be avoided.
All right. So we have another question. So the questioner asks, could you explain why the multiple dependent claims are allowable? Your example, claims 3 through 8, first claim set, and claims 4, 5, 7, second example set, usually raise objections during PCT, ISA, EP examination. Are they not allowed in the US or PCT, but are allowed in EPO during national stage?
The issue is if they are allowable, dependent upon the examining practice. And the simple answer, if you're using the US as the receiving office, then you will receive an objection. If you file these at the European Patent Office, then the EPO as the receiving office will not object to multiple claim dependencies, because it is something that they're allowed to accept. So it is a different, this is an example of national practice impacting on an international filing system, which is, somewhat strange. I'll give you another example of this recently in a case where the EPO examiner recited a sort of 101 type rejection based on EPO practice, which was not really compatible with the PCT reading, should we say. And again, they're saying, well, and he did actually sort of recite, well, I'm applying EPO principles here. Well, you're supposed to be acting as an international search authority. So national practices impact on the two. So if you're filing in the USPTO, you have to use USPTO. If you're filing your PCT, or obviously a US at the USPTO, you have to have single dependencies. You have to comply with US rules. Put the examples at the back. If you're filing, and then when you enter the regional phase in Europe, you can expand it up. European examiners are perfectly happy examining multiply dependent claims. They have absolutely no problem with it. So when you file in the EPO as the receiving office and use the use the EPO as the examining authority, or searching authority rather, they will be quite happy with that. I hope that answered that question.
Great. All right, so the next question, yeah, for filing in the PCT, if you knew you were going to file in both Europe and the US, is there any reason not to file sets of both types of claims?
That's a good one. Yes, that's a great question. That has been a practice that has been sort of used before. The problem is if you file both sets of claims, I'm not sure how you sort of file two sets of claims, they just have to be continuous numbered. But the USPTO would object to the multiple dependencies. If you use them as a receiving office, you'll get a formality objection, or excuse my ignorance, I forget the procedures, but I'm sure you're going to get a rejection of those claims. But of course, as a PCT receiving office, you don't have to pay claims fees, so that's not a problem. But the if you're using the the USPTO as a receiving office and indeed as a searching authority, they won't be happy. So filing two sets of claims does it, if you like, that just doesn't help. It just complicates things. You need to pick an office and use the claims that suit them. If it's the USPTO, you have to have the belt and braces examples at the back to provide the basis requirements. If you can file at the EPO, now I'm not talking about filing, it's the receiving office. And of course, the important thing is you can only file at the receiving office of which the applicant is a national or resident. So you can't pick and choose the receiving office. That's not, you can choose a search authority, but not the receiving office. So, I would advise against putting both sets of claims in, apart from ensuring that the language is in the claims for the multiple. So we're back to that, those numbered examples.
Yeah, and to expound on that, Albert did provide a nice comment in the chat section. The U.S. receiving office won't object to multiple claim dependencies. They'll only object if they're the search authority. So if you're using the U.S. receiving office because you have to, but you're using the EP as your search authority, then your multiple dependent claims will get searched in the PCT process. But if you're using the U.S. as a search authority, they will likely object to the multiple dependent claim format. And what John explains here is why he was also suggesting, and why in the Schwegman practice, we really encourage people to use the examples section and do the examples very carefully in a multiple dependent form. And then, the claim set itself that you file, because we often are filing for our clients in the US first. So, our PCT filing often sort of mirrors the US filing, and we're relying on the claim examples section to support, any multiple dependent claim sets that we file at national stage.
I think that's the important point there, Greg, is it's the first filing. This going back to the priority. Please, everybody, don't use provisionals wherever you can convince your clients, because they cause immense problems from the basis requirements. Properly drafted provisional first filed US application with examples in will provide solid foundations for international patent protection for the scope of claims.
So someone has asked a follow-up question. Doesn't the US allow multiple dependent claims?
It's not practice. US practice. You're allowed, as I understand it, you're allowed to depend multiply upon singly dependent claims, but then you pay the claims fees. But you're not allowed multiply dependent on multiply dependent. Am I correct there, Greg? I'm not a US attorney, so.
Yes, that is the correct interpretation of the US law.
Yeah.
Yeah.
So,
and the big reason it's not done typically in the US is claims fees. We typically don't even, at least myself and most US practitioners I know, don't typically use multiply dependent claims, mainly because of the fees involved. So.
Yeah, the fees become horrendous. The sort of 3+20 rule in the US, and staying within that. is almost universal, I'd say, from what I see from my side of the pond. In the same way, almost universally, we stay below 15 claims in Europe.
Okay, I am not seeing any additional follow-up question. Oh, wait, we do have another question. Would a reason for filing EPO claims, even in the US, even if the US is the International Search Authority, be that you are 100% sure that the subject matter is in the priority application, the PCT? So what the person's asking is, should you be filing these multiply dependent claims to ensure that you have literal support, in the priority application?
Well, the answer is yes, but use them as examples. If you're filing at the USPTO, the practice should be, Schwegman's practice is, if you're filing in the USPTO, put numbered examples at the back and make sure you make them. There's no point if you're just going to simply keep single dependencies. That's pointless. Put examples at the back of your US file specs with multiple dependencies carefully thought through. Try to reach through for all those complicated arrows that I showed you in my diagram, and use those in examples. Focus the claims on the national practice, but provide the backup for the other country. And the problem country is Europe. I'm afraid we are a problem in Europe. It's a real headache for us.
So William added a nice comment about the PCT rules. PCT rule 6.4 says multiply dependent claims shall not serve as a basis for other multiply dependent claims. However, he also pointed out that he has never seen the EPO as the International Search Authority object to multiply dependent claims depending from other multiply dependent claims.
That's interesting. In all my years of practice, I didn't know it was actually in the PCT rules, because the EPO have never ever raised an objection.
Yeah, and I think that was William's point, and it's well taken. I agree. I don't know that I was aware that was in the claims, but typically my practice is that I'm filing them in an example section, and I'm not actually filing a multiply dependent claim set in the PCT. So.
One point about filing in Europe, whether you're filing a PCT using Europe as the receiving office and the search authority, or whether you're filing an EP national, or indeed, as I've now learned, which is interesting, that you could, it seems, file a PCT at the USPTO with the EPO as the International Search Authority. It is very advantageous to include the multiply dependent claims in those applications, because the EPO will perform a search based on the claims. And the EPO, again, can be quite difficult in saying that they haven't searched some things sometimes. So if you haven't presented in the claims all of the possible claim combinations, and later you introduce them when you enter the regional phase in Europe, for example, they may say, but we didn't search that combination, pay another search fee, or actually file a divisional. It's happened. And so I would again recommend the multiply dependent claims to say, look, we want all these combinations are possible, and we want it all searched. We don't want to be caught out by saying you didn't search it later. So I think that's another reasonable reason for wherever this is going to end up at EPO, follow their practice, even if it is contradicting the PCT rules.
Yeah, good point, John. So Jill has provided an interesting alternative. So alternative to putting claims in the example section, is there any reason not to enter claims with multiple dependent claims and then simultaneously file a preliminary amendment to amend for the US claim set? I assume that she's focused on, a US filing. I don't see anything particularly, wrong or problematic about that. John, your thoughts?
I agree. It just adds another step in the process. I mean, the other process, there is something particularly in UK law, that we get worried about in possible litigation is public interest sometimes comes up. And by deleting some claims, are you abandoning that subject matter, and should you have the right to return to it? So I would say that again, it's just more difficult, and does then add a possible argument to a clever litigator that you abandon that subject matter and shouldn't have it back. Apart from a docketing perspective, you've got to make another step. Whereas simply cutting and pasting and doing a global replace for the word claim with example is pretty darn easy in the back of your US specs. Any more questions out there, guys?
So far, I'm not seeing any, but it's been a good discussion so far.
Okay. Well, I think, the point about this is the thought process, and not simply just doing global dependency on everything is, I think, a take home from this, that it is, and using these examples at the back would be very useful for providing strong EP protection. And yeah, you can always send questions later if something comes to you. You can contact us and get in touch with anything that comes up later.
Oh, quick, John. There was a comment earlier that I missed.
Okay.
The person was kind enough to re-enter. Do you recommend including a technical effect or advantage while adding the dependent examples? So I assume this is sort of within the example section that we've been talking about. Is that?
Yeah. I mean, this goes back to the old practice, which unfortunately we've had to adapt even in Europe. In the old days, you wrote a summary of the invention, which I know the US practitioners and US practice not really happy with, but we used to go through and recite each of the claims as an embodiment, and then maybe comment about them. And this is something you do in your summary regarding this is a good idea, this has this benefit, this sort of thing. The problem with using that is that there is no explicit dependency by numbering, and using the word embodiment, which is not really a subject of this presentation and conversation overall, but the word embodiment is a massive problem in the EPO. If you've recited embodiment, unless you say explicitly that embodiment can be used with the other embodiment in an explicit, specific manner, then they are different embodiments and you haven't disclosed their combination. So that we've moved away from that practice and now we use these numbered clauses. So yeah, there is absolutely no way, no reason why not, why you shouldn't, in between your claims, should we say, add some commentary. And in fact, that is a very interesting thought. And thank you very much. I've not thought about that one. It's always good to have these conversations, even though somewhat remote. That is a good practice, I would say, because you are providing combinatorial disclosures at a high level. And if you can make comments about the benefit of them, this has the advantage of this and this together, then absolutely brilliant. There's no, that doesn't do you any harm, I believe, again, and provides some additional support when it comes to arguments, particularly with European examiners, when sometimes they're saying, we don't think it's inventive, we don't see, the technical effect. And you say, well, look, it's explicitly stated as to what the technical effect is. Of course, you can't just make something up, but if it's explicitly stated there and it really is technical, then that does help your case. So yeah, that is a very good point. Thank you. And I would suggest that it's worth thinking about. Yeah.
All right. Well, John, I'm not seeing anything further. You want to wrap us up? It's been a good discussion.
Well, thanks for listening, guys.